Okay, so having had some tutorial based upon our last week lecture on the first part of discussion of historical evolution of Ghana's constitution, we would like to continue with the part two of our discussion of the historical evolution of Ghana's constitution. Now, just a quick recap. We noted from our first part of our lecture last week that before introduction of a colonial rule, the present day Ghana was not a uniform society in terms of having a common leadership, as it were. We have different kingdoms, chiefdoms, and these kingdoms and chiefdoms had their own traditional governance arrangement. In some cases, we have a centralized societies, and then a non-centralized or acephalous and autochthonous groups. And these traditional societies had their own arrangement of governance, and the authority of those who govern was either derived from some ancestry in terms of like a blood land, or derived from some divine or spiritual claim, as it were. And that had implication for legitimacy of their authority, and also obedience which their subjects yielded to them. Because if you disobey their decrees and their ordinances, it was not just ordinary leaders, but you had also sort of like defied the religious belief, as it were. Now, we saw how that gradually became affected by the coming of the British when they started initially as trading merchants, George McLean and so on. As part of the trading arrangements, the British eventually acquired forts and castles, which other traders had established and had left the coasts. And having acquired them, establish some kind of administration for those who were trading along the coast. And gradually, there was this leader, McLean, which came, who became interested in trying to expand his sphere of influence to areas beyond the forts and the castles, to some of the communities along the coast. And how, in the course of time, problems were created, and as a result of the problems created, the British government set up a committee to look into it. And then when they set up a committee to look into it, it was realized that the authority or the administration, which the colonial officials at the time, that is McLean and co, were exercising, they don't have proper legal basis, and they had arrogated to themselves a lot of powers or authorities that, strictly speaking, they did not have under the law. So to cure that, to overcome that manifest omission or deficits, they passed the requisite legislation, the British territories, and then the foreign jurisdiction legislation, which sought to provide proper foundation for the necessary order in councils, the necessary legal authority to be made to rationalize and legitimize the authority that the the British officials were exercising beyond the forts and castles. And we saw how, within the context of the various developments, we had the monumental agreement known as the Bond of 1844 being executed by the British administration and some of the Fanti chiefs, through which the Fanti chiefs, as traditional leaders, undertook to abolish certain practices which the British officials had considered to be improper, to be dehumanizing, and outmoded, and also for them to agree for certain types of dispute or offenses to be tried using the British model of adjudication, especially so where heavy offenses and heavy sentences were to be meted out to the offenders. So that is the famous bond of 1844. And we saw how it was executed on 6 March. And we said that that certainly had implication for the date on which the Gold Coast sought to assert or declare independence, because the independence was declared on the 6th March, 1957. Then we also saw how over time there was various constitutional changes, and these changes incrementally, that is gradually, sought to respond to agitation by the native people, whose agitation were championed by their elites or the intelligentsia, as it were, and ultimately got them involved. Initially got the intelligentsia, some of them involved, and then later on too, the traditional leaders also wanted more involvement or more say, and various constitutional amendments were made to accommodate that. So if you look at the trend, if you look at the path or the trajectory along which the various constitutional changes took within the first phase of the colonial era, you notice that each subsequent constitution which was adopted was an attempt to improve the preceding one, an attempt to provide solution to certain constitutional problems and crises which had actually confronted the previous constitution. So that was the general trend. And we then ended our class on the very landmark constitutional development known as the Constitution of 1925, under the auspices of Sir Gordon Gorgesbeth. And we saw how that constitution made sweeping changes and trying to provide very welcoming responses to some of the problems which were actually faced. And we noted that that constitution was actually noted for trying to address some of the demands which had been advanced by the Aboriginal Right Protection Society, starting from 1897 thereabout. And also how the chiefs and then the various emerging municipalities were given more involvement in the legislative council and the executive council. And then the elective principle, as we noted, was also adopted for the first time as far as composition of the legislative council was concerned, other than what used to be the case previously, where people were just handpicked according to the whims and caprices of the colonial administration. So we also saw the provincial councils, how that was also introduced, especially the prominence which was given to the traditional authorities. So it was on that note that we ended the last class. So we continue with our exploration or discussion of the evolution of Ghana's constitution, moving on from the 1925 to another major stop, the Constitution of 1946, known as the Alan Burns Constitution. And that constitution was very important constitution for a number of reasons. And one significant development is what we call introduction of the representative government for both the colony and Ashanti. Now, let me emphasize this. The colonies, properly understood, that is, the founding communities and all the other parts, excluding Ashanti, and of course, it will take a while before the northern territories are also included. Now, the Ashanti, or what we call the Ashanti, of course, Ashanti is the anglicized version of Ashanti, but the proper thing is Ashanti. That is the original, Africa way of pronouncing it. Now, the Ashanti were actually defeated. So let's keep that in mind. They were defeated by the British in war. So that is what led to establishment of their authority over there. So let us appreciate that. But for, as you notice, the other coastal communities, the colonial authority extended their rule through Treaty of Friendship, including like the bond of 1844. But the Ashantis had a couple of wars. They beheaded, Sir Charles McCarthy, and then the British decided to also revenge that, and you saw how that actually manifested. And eventually, in 1901, how the Ashantiwa War, and then the other Sagrenti War, and so on. So for them, it was a matter of like, conquest. So that is why the Ashanti was treated separately from what we call like the colony. And if we look at the Burns Constitution again, it could be argued that, and as Professor Kumado rightly notes in his work, that since 1850, it is the Alan Burns Constitution of 1946, so to speak, which for the first time introduced what we call African majority in the Legislative Council. The Legislative Council was the legislature at the time. And for the first time, in terms of membership, the Africans were given the majority. If we look at it, so let us keep that in mind. So the other features, apart from the representative government and also the majority given to Africans, was the abandonment of the what you call official majority principle. The official majority principle means that the colonial government, through its various officials, were to be given more seats in the legislative council, but that was actually abolished, and African who were the unofficials, in other words, they did not have like position in colonial government. They were rather given more seats in the legislative council. So let us keep that in mind. And again, if we take the Standing Finance Committee, Africans were also given more seats, the majority seats on the Standing Finance Committee, meaning that Africans were now going to have a greater voice in how revenue was created and how revenue was expended. And we also had, for the first time, having a representative from Ashanti in the Legislative Council. But those who were to serve on the Legislative Council, they had to have some form of allegiance to the golden stool, that is the Ashanti, and they were 4 in member. So they were selected by the, if you like, the Ashanti Confederacy. But then the governor retained his dual powers of veto and also reservation. So the veto power simply meant that the governor could override whatever the majority in the Legislative Council had voted as far as lawmaking was concerned. Or instead of overriding, it could make a reservation with respect to a particular proposal as it were. So let us keep that in mind. Again, there was also inclusion of representative of the Joint Provincial Council of Chiefs, and they were expressly made integral part of the constitutional machinery. But the point needs to be made that to serve on the Joint Provincial Council of Chiefs, which had now been made integral part of the constitutional machinery, you needed to be a paramount chief, recognized by the government as owing the necessary allegiance to a particular customary law. And that practice is foundation of what has carried on into the modern day. If you look at our Constitution and the Chieftaincy Act, if you are a paramount chief, you need to be gazetted for your status in terms of legitimacy to be completed. So the practice of gazetting chiefs is something what is not just that. It has a background to some of these pre-independence colonial constitutions. So let us keep that in mind. Of course, Alamban's constitution also introduced provisions which prohibited the consideration of any matter which would dispose of public funds or impose or taxation without the approval of the governor. So that provision is also quite significant in terms of what we have in our own constitution. If we look at our current constitution, particularly Article 108, there is a provision to the effect that if you are going to get any bill introduced in Parliament, and that bill is going to have implication on state funds in terms of imposing tax or in terms of being expenditure on state funds, such as the Consolidated Fund and other state funds, that bill must have the blessing of the government of the day. It must be initiated by the government of the day. So a private member's bill cannot actually impose tax or cannot be a charge or cannot be an expenditure on any of the state funds. Now that practice goes back to the Alan Burns Constitution of 1946. So let us keep that in mind. Of course, the Alan Burns Constitution also introduced a native to Executive Council. The Executive Council, largely the executive arm of government, the cabinet and all that. For a long time, it had been the white British, but the Burns Constitution allowed more natives to be introduced to that council. So that is a major development. So let us keep that in mind. Okay, so we will quickly jump to the 1951 Constitution. But the point to note about the 1951 Constitution was that there were certain problems in the Gold Coast. And those problems actually gave rise to disturbances in the period between 1948 and 1949. And the disturbances also involve boycotts of European businesses. That is to say that the local people decided not to patronize goods and services provided by the expatriates, the Europeans. And that boycott was led by a gentleman known as Ni Abina Boni. He was the Osu Alatamanche, that is the chief of Osu. And certainly that agitation brought a lot of unrest, and it's also provided impetus for the formation of an offshoot of the first political party. So the first political party was the UGCC, United Gold Coast Convention. And the United Gold Coast Convention, as we know from the history, was that they wanted political independence of the Gold Coast within the shortest possible time. Now, the New Boy agitation between the 1948 and 49 provided impetus, provided some momentum for the Secretary General of the UGCC, Kwame Nkrumah, to actually break off and set up what we call the CPP, Convention People's Party. And the Convention People Party took advantage of the euphoria which had been provided by the Niboy Thompson's boycott of European businesses. And Nkrumah declared what we call the positive action in 1949. And the positive action of 1949 also meant that the CPP was asserting its aim, political governance now, as opposed to political independence within the shortest possible time, canvassed by the UGCC or the United Gold Coast Convention. Now, this developments prompted the governor at the time, Sir Alan Banks, to actually set up what is known as the Watson Committee. The Watson Committee investigated the various disturbances to try and understand what was happening. And the Watson Committee actually described Alan Banks' Constitution of 1946 as being outmoded at birth. That is to say that as far as that constitution was concerned, before it was even introduced, it was not fit for purpose. So this was the finding of the the Watson Committee, which had been set up by Governor Alan Banks. And that suggested that there was a need for a constitutional review or constitutional reform committee. So a 40-member All-African Constitutional Committee under the chairmanship of Sir Henry Kusi was actually set up, and its made proposal for reforming the Alan Banks Constitution based upon the various findings which the Watson Commission had made following the declaration of positive action by Nkrumah's CPP and so on. So what was the mandate of the Kuse's Constitutional Committee? Among other things, was to, their recommendation, among other things, which they submitted, was that there was a need for enlargement of the Legislative Council with a view to making it more representative of the then Gold Coast as a whole. And then again, it also recommended that the executive committee should have African majority. However, the three executive, the ex-officio members, namely the Colonial Secretary, the Financial Secretary, and the Attorney General should be retained, meaning that despite the fact that Africans were going to majority in the executive arm of government, certain key position, the Colonial Secretary, who was an ex-officio member, and then the Attorney General and then the Financial Secretary were to be retained by the British. And it's also recommended that there should be a bicameral legislature. That is an upper house or Senate and a legislative assembly, and also modernization of local government. So these were some of the proposals. And you notice that these proposals largely made their way into the constitution, which was adopted by the then colonial government, leading to what we call the 1951 constitution. So you notice that there's an important shift of governance from the colonial authority to the Africans, to the natives, as it were. If you take the Legislative Council, for example, the name changed to Legislative Assembly, as we've indicated, and almost all the members were elected the Gold Coasters, about 75, only 10 unelected. There's also Public Service Commission. We also had the provision that budget estimate of the civil service was to be approved by the Legislative Assembly. So there were major important constitutional development. But one noticeable thing is that if you look at the fact that the ministers were to be appointed by the governor from the assembly members and approved by the assembly, That is somewhat similar to the current provision in Article 76 to 79 that majority of ministers should be selected from Parliament. Of course, that has its own challenges, and as we move on with our exploration of the current constitution, we will have a more debate as far as the constitutional provision, which says that majority of ministers should come from Parliament, is concerned. So let's keep that in mind. Well, in 1952, there was an amendment of the 1951 Constitution. Now, previously, there was what they call the leader of government business in Parliament. Now, that was created as the office of Prime Minister. So the Prime Minister was now a member of the Legislative Assembly. The Executive Council was now called Cabinet. So we see that gradually the constitutional machinery was becoming similar to that which pertains in any mature democracy at the time, including the metropolitan Britain. Yeah, so in 1954, we also had what could be called Nkrumah's Constitution, as it were. So that constitution was contained in an instrument officially known as the Gold Coast Constitution Order in Council, 1954. And this constitution reflected the radical posture of Kwame Nkrumah and his CPP. Especially so when you look at the fact that most of the things contained therein were similar or mimic the Westminster model of constitutional governance, as it were. So some of the key things, we have like the three main organs of government. So now we have like a full-blown legislature, executive, and the judiciary. And they're all clearly identified with their powers and functions. So that is quite significant. Again, if we look at section 6 to section 22 of that instrument, we had a fully defined cabinet system headed by the Prime Minister. Then the Legislative Assembly was also enlarged from 85 to 104 elected members, with the Speaker in a single chamber. So we didn't have a double chamber, just a single chamber. Maybe just like the House of Commons. We didn't have the equivalent of like the House of Lords, as it were. Then the Chief Justice was to be appointed by the governor in consultation with the Prime Minister. Other judges were to be appointed by the governor in consultation with the Judicial Service Commission, which have been created by the Constitution. So you notice that some of those provisions are a bit similar to what we have now. Now we look at the current arrangement. The Chief Justice appointed by the President in the consultation, the Judicial Council, advice of the Council of State, approval of Parliament. And then the same thing applies to like the Supreme Court judges, and then the other Superior Court justices, in consultation with the Judicial Council. Again, the governor retained his veto power still under the 1954 Constitution, and also power to reserve and certify legislation to the pleasure of the Secretary of State for Colonies in London. So the power of reservation simply means that if you go to London, there was a government minister called the Secretary of State for the Colonies. like the a foreign minister responsible for the various colonies of Britain. So if you are the colonial government, you're not happy with a particular proposed legislation which has been passed by the Legislative Council, and you didn't want to veto it, you could refer it to the colonial Secretary of State and state your reasons or your concerns with that particular legislation and abide the outcome of his decision before you could go on as to whether that legislation passed by the Legislative Council should be assented to or not, as it were. So if you look at the 1954 Constitution critically, one could argue that there had been a full internal self-government. That is to say that as far as internal affairs or governance are concerned, the colonial government did not have much say, but rather it was the elected natives, Gold Coasters, who were very much in charge of things. So that was how significant the 1954 Constitution was. Now, in 1955, there was an attempt to reform the Constitution, and that was actually rejected, as it were. And around that time, there had been so many political movements, including the Northern People's Party, NPP, not the current New Patriotic Party, and the Northern People's Party. Their main interest was to protect economic interests of the relatively underdeveloped Northern territories and to resist Northern domination. So if you look at it now, if you look at Ghana, Ghana has been going through a lot of shits. So for a long time, it's like the Southerners have dominated the political space. Now, if you look at now, it's like it's now the time for the northern regions for also provide a more dominant leadership for Ghana. So this has a long history going back to even like the pre-independence colonial era, as it were. We also had the Togoland Congress Party, which was interested in the merger of the British Trust Territory of Togoland with French Togoland instead of being merged as minority with the independent Gold Coast. If you remember, following the defeat of the Germany in the Second World War, the colonial interests they had all been taken over, and the UN had created something like a trust. So present-day Wuta region was part of that which was previously owned and controlled by the Germans. And that is why if you look at the Ewe language, okay, if you look at the alphabets and how it is written, you can see some linkages with aspect of some of the German language that explains it. So that's a little bit of a background there. But following their defeat in the Second World War, they had now lost control. So we had a political group called the Togoland Congress Party, who didn't want the present-day Vuta region to be made part of Ghana, which seemed to be gradually on the verge of attaining independence, and rather wanted it to be part of the French-speaking Togo. So that was what that political party stood for. And then we also had the National Liberation Movement, NLM, which was launched in Kumasi in 1955 to fight for larger share of cocoa revenue for Ashanti, especially when CPP declared its policy of using national revenue regardless of where it is generated from, whether it's generated from the forest belt, it's generated from the coastal belt or the northern regions, it was going to be used for purpose of countrywide development. And this was resented by the National Liberation Movement because they thought that the Ashanti, and Ashanti for the historical purpose included modern day Brun and Hafo. And those were the places where the cocoa was largely cultivated and the revenue so created. And they did not like the fact that revenue from there was used for development of the whole of Ghana. And they were also not happy with the producer price, which was being set by the central government. We also had the Muslims Association Party, which also was supported by the Kumasi and the Colonial Zongo areas. And so many other splinter groups, including the Gamashi Party, which also sought to preserve Galans for Ga people. So these were the bigger contests as far as the post-1954 constitutional developments were concerned. So let us keep that in mind. So the various opposition, including the NLM, wanted creation of a Council of States in which certain high-ranking members of society would actually be given seat. And then they also wanted second chamber of parliament, like the upper chamber, maybe like the House of Lords or the Senate. And they also wanted the federation, especially the NLM. They wanted an arrangement in which we have like federal states, you have like the state governments and then the federal government. And that way, let's say that those in the Ashanti, they will have their local governance, and a lot of things will be controlled from there. And they also propose autonomy of regional councils, like the various regional councils which have been set up under the 1954 Constitution and all that, should be given autonomy, just like if you go to maybe Northern Ireland. Northern Ireland is part of the United Kingdom, but they enjoy autonomy, just like the Scottish Parliament and also the Welsh Assembly. So that's what they wanted. But they were also rejected. And also they also wanted comprehensive code of fundamental rights. All those were rejected. And as a compromise, we have the bonds constitution, which we will discuss at our next class. It's a bit late now, it's 9:15. So we draw the curtain down and we will continue from here and hope to end at our next class. But next week, we have a quiz from the preamble of the Constitution up to Article 56. So get ready when we meet in class. Thank you. Have a good night.